So good afternoon, everyone, and welcome to our webinar, Estate Planning Essentials. This is our fifth session in our Beyond the Portfolio series. Over the past few weeks, we've heard from Medicare expert Jamin White, family caregiving expert Annalie Kruger, long-term care expert Scott Olson, and last week we heard from David Gastworth, who's an expert in life and disability insurance. If you've missed any of those, they're on our website, www.scentman.com. We have a section titled Webinars. Just click on that. You'll see upcoming webinars like today's, and then all the recorded webinars are just below that. So if you haven't had a chance to listen to all of them, I'd encourage you to do so because there's a lot of really great information in these programs. So like those, today's session is going to be recorded as well. Along the way, if you have questions, please put them in the chat box or the Q&A box at the bottom, and we'll do our best to get to all the questions, and then we should have this recording on the website probably late tomorrow or Friday at the latest. So anyway, now today I'm excited to introduce to you our guest, Mathew Jacob. Mathew is an attorney with over 26 years of experience, and he runs his own firm, the Jacob Law Firm here in Austin. He specializes in estate planning, commercial real estate law, along with business and corporate law. Mathew earned his bachelor's degree from the University of Texas here at Austin and received his law degree from Baylor University School of Law. I've known Mathew for about 15 years, and he's helped a number of our clients, and he's helped me with my own personal estate plan over the years. So I can tell you that Mathew is extremely knowledgeable, very nice, a man of great integrity, and he's a wonderful family man to boot. He's all about his kids and his family, and that's a big deal. So I'm thrilled to introduce my friend and colleague, Mathew, today to share his insights and wisdom on all things estate planning. So be sure to ask some good questions. So Mathew, the floor is yours.
Wonderful, and I really appreciate that that glowing intro, Scott. You're very kind. Yeah. I really appreciate all of you attending here today. I know you got plenty of other things to do with your time, and especially during business hours. So really appreciate you all attending, and hopefully we'll be able to convey some information that's of interest to you. As Scott mentioned, the name is Mathew Jacob. I have my own law firm, the Jacob Law Firm here in Austin, right here off of 360 and 2222. And been practicing for 26 years. Went to UT and Baylor, Baylor Law. And part of the reason why I chose Baylor is just because they have a very strong litigation program. And that's what I wanted to do going into law school. I wanted to be a litigator. I wanted to, just try lawsuits. And what I found out after litigating for a few years is, a big reason why people actually end up in the courts is, especially if it's a business case, the contracts were poorly drafted, or if it's a probate litigation matter, a contested probate, it's because they didn't have, proper wills or trusts or documents that had very protective language in them. Or if it's a contested guardianship, an incapacitated individual who, didn't have their documents in place either. And what I realized at that time earlier in my career was, I'd rather practice in prevention rather than intervention. I'd rather help people stay out of the courtroom instead of intervening after they're already embroiled in a lawsuit, because obviously they're stressed, they're having to pay a bunch of money to lawyers, and it's not a good situation, especially if you're dealing with somebody a loved one of yours who either passed away or is incapacitated. Not having to deal with the courts in those scenarios is absolutely ideal. And that's one of the main reasons why I'm here today is to help you figure out how best to stay out of the courts and focus on your family rather than, potentially having to shell out not just a few $1,000s for documents, but tens of thousands of dollars in legal fees, and sometimes it gets into the hundreds of thousands. So that's what we're here today. And Scott,
Yeah, you go ahead and share your screen.
yeah, let me go ahead and do that. Bear with me a second here.
Mine.
No, I just need to get to the right screen. Bear with me. There we go. Okay.
I can use mine if you like.
What's that?
I can use the copy you sent me if it's easier.
No, it's just I have multiple screens open. Just a second. Okay. All right. Can you guys see that?
See your screen, but not the slides? There you go. There we go.
All right. Welcome to 2024, right? I think I'm stuck in the 90s at this point. But anyway, here we go. Protecting your legacy with proper estate planning is the title of the PowerPoint here. And basically what I want to talk to you guys about is your estate. What does it include? Who is it for? The various ways to transfer assets to your loved ones. And then we'll get into some other issues, time permitting, as far as, protecting your real estate investments and your business assets, things like that. So with that, let's just go ahead and move forward. Now, an estate is everything you have, your bank accounts, investments, life insurance, retirement, personal property, all of that. Everything that you have is included in your estate. And we'll get into a little later what's the difference between probate assets and non-probate assets. But for now, whatever you have is your estate. Now, why do estate planning? Well, first of all, you want to make sure that after you pass away, that your trustee or your executor or whoever it is that's in charge of transferring your assets has control over those assets, and that you minimize, the legal costs, taxes, things of that nature. And also, if there's an incapacity, you're still living, but you're not able to make decisions for yourself. Let's say it's Alzheimer's, or if it's a car accident or something like that, you need to make sure that you've appointed people that can make decisions on your behalf, whether that's financial decisions or medical decisions. So we'll cover those things here moving forward. Who needs estate planning? A lot of times people are like, well, I don't need an estate plan. I don't have much. Or they think that, well, my assets are non-probate, such as retirement or life insurance. So they're never really going to be subject to the probate courts or anything like that. Or I have beneficiary designations on my assets. But you want to make sure that those things are done properly. And, yeah, it's good to have beneficiary designations, but make sure that the way that you've designated beneficiaries with respect to those accounts is done properly so that, your family doesn't end up in the probate courts anyway. Obviously, it applies to people that are, in their senior years, but also for people that have young children, and even people that are not married or don't have children, and also people that are just starting out in college. My eldest daughter, I have 3 kids. She just started her first year at the University of Kansas. She's a tennis player. I'm super proud. But, I prepared some documents for her because she's an adult now. She's 18, even though she's still my little baby girl. She's 18. She can make decisions for herself. And what happens if something happens to her? She had called me just 10 minutes before this seminar to tell me that there were, something that popped up on some blood work that was done. I'm like, man, really? So you just never know. And you want to make sure that you have things that are in place to make sure that folks can step in and make decisions when you're not able to do so. I have some examples here of some people that actually had wills, but it ended up not being a very good plan. We all know who Elvis Presley is. His estate was worth a little over $10 million, which doesn't sound like a whole lot now, but back in 1977 when he passed away, it was a good chunk of change. Well, he had some debts that had to be paid off, and then there were some administrative and legal fees, which when you couple that with the estate tax, that was, well over $5 million. That was half of his estate right there that the family is never going to see. So, after taking out the debts that were owed, all of the legal fees and estate taxes, the family was left with little under $1 million. Now, of course, his estate continued to generate revenues well after his death, so that's not factored into this total. But this is an example of how, even if you have a will, there can be prohibitive costs, and you need to be aware of how to avoid those types of costs. Another example, this is on the disability or incapacity side. Groucho Marx, he had a will, but he didn't have disability documents in place, meaning a medical power of attorney, a financial power of attorney that designated individuals to make decisions on his behalf during this period of incapacity. Well, a guardianship had to be opened up by the court, which is very expensive. And then, somebody else was designated to take over and make decisions on his behalf. And, the family no longer had control over medical decisions or financial decisions, and it created a lot of problems. It was all, because it was in the courts, it's all public record, lost all privacy in that regard. And again, the costs were extreme. When should you plan? Well, now would be a good time. Everybody always says, well, I got 30 other things that are on my plate today. I can't get to it. I'll get to it when I get time. And, oftentimes it ends up being too late. So do it while you can, while you still have the ability to make decisions on your behalf, and before you need it. Just like we all go out and buy auto insurance, home insurance, things of that nature. We hope to never have to use it, but it's there in case we do. And now I want to go over different ways, the primary ways that assets are actually transferred over to your loved ones. I mean, we work our butts off every day, blood, sweat, and tears to make a living, and we hope to, leave a legacy for our family members. A lot of you are clients of Scott's, and you're taking the advice that Scott and his team are giving to you so that you can accumulate your wealth and hopefully pass it on to your family, perhaps to charitable organizations. But obviously you want to make sure that you have full control over it and the least amount of money that's charged to you as a result. So these are the common ways that assets are transferred over, either by a will. You don't do anything and you leave it to the courts. Joint ownership. You may gift during your life. There are beneficiary transfers or beneficiary designations. And the last one is a revocable living trust. So let's spend a little bit of time on those things. A will, I think we're all familiar with what a will is. A will is a document that expresses your wishes as far as who you want your assets to go to. It also controls assets that are titled in your name, like your house, your bank accounts, your investment portfolio, real estate investments, things of that nature. And obviously you have to go through the courts to make sure that will was executed properly, that it's valid and enforceable in the state in which you live, and that it identifies an executor in the will who will serve, hopefully independently without bond, and make sure that whatever debts exist are paid off, and then whatever is remaining is distributed to your loved ones. Now, as I'd mentioned earlier, there are probate assets and non-probate. Real quick, non-probate assets include things like life insurance, retirement accounts, assets that have beneficiary designations, where once the person passes away, you produce a death certificate, and whoever is managing those accounts will distribute those assets to the people that are identified on those beneficiary designation forms, and you don't have to go through the probate process. But there are times when there are issues with those beneficiary designation forms, or they weren't even filled out in the first place, and you end up having to go through probate for that anyway. Probate assets are things like your house, your bank accounts, your investment portfolio, some of those things that I had mentioned earlier, your personal property, things of that nature. So, when we're talking about a will, we're talking about those types of assets. Now, what is probate? It's a legal process. Where we are right now in Travis County, there are designated probate courts. Some other counties, smaller counties, such as Williamson, which isn't so small anymore, but they don't have designated probate courts. They have the probate cases are they go through the county courts at law. So, not all counties have probate courts and judges that are, only dealing with probate cases. So sometimes that factors in as well, as far as, how knowledgeable is this particular judge in probate law at all. But when you have a will, it has to go through the probate court in order for it to be validated. And also for the executor that's named in that will to be appointed. There's a process in Texas, and it's a relatively simple, straightforward process. You have one hearing, especially if it's uncontested. You'll have this hearing, and you just do this relatively simple prove up for the executor to be appointed and for the beneficiaries to ultimately receive their distributions. But there are legal costs associated with that, and having to hire a lawyer to make sure that all the requirements under the estate code are met, and that the executor is appointed. All of the large counties in Texas, Travis, Harris, Dallas, Bexar County, San Antonio, all of those require the surviving spouses or whoever it is that's going to be serving as the executor to be represented by counsel, just because you can't represent somebody else. You can represent yourself in court, but when you're representing an estate, you have to have a law degree to represent that estate. So it's necessary to hire an attorney to assist you through that probate process. And the primary reason for going through probate is to have the legal authority to change title to your assets from your name, or if you're married, from yours and your spouse's name into the surviving spouse's name, such as title to your house if it's in yours and your spouse's names. And obviously it has to ultimately be the title has to be changed to the surviving spouse's name, and probate is the primary way to get that done. Now, this is a little illustration of how the probate process works. You have all your assets up here. They funnel through the probate court, and you have probate fees, which include attorney's fees. If it's a taxable estate, meaning it's subject to the estate tax, the federal estate tax, or maybe you live in a state that has a state tax for the state, then that may leave a lot less money for your heirs. So those are all things to keep in mind when it comes to going through the probate process. Now, one thing that a will does not do, it does not have any bearing on an incapacity. It only deals with death. So if somebody, becomes incapacitated, the will's not going to help. It's important to have a durable power of attorney in place that would allow somebody else to step in and make financial decisions for you. And of course, to have a medical power of attorney and HIPAA authorization and an advanced directive in place to make medical decisions. So keep that in mind as well. If you have a will, you're going to need to have these, what I refer to as disability documents in place also. Now, what if you decide, what if you don't do anything? And again, like I said earlier, it's natural for people to put off having an estate plan in place. Oftentimes, it's just not something that you want to think about. You don't want to think about your own demise or becoming disabled at some point. And you have other things that you're worried about on a daily basis. And the majority of the time, that is the case, because there are statistics out there that say that upwards of 70% of the population don't even have basic wills. So what ends up happening, these things that you're putting off, or maybe you don't want to pay a lawyer to do these things, it ends up costing the estate a lot of money. And it has to be done twice. If you're married, there has to be two separate probates after each spouse passes away. So again, those costs definitely mount. So, you know, same thing applies if you are disabled. There may be a guardianship that has to, you got to go through that guardianship process. Also expensive, also can be contested because there may be a disagreement as to who that guardian should be. And in Texas, there are two types of guardianships. There's a guardian of the estate and a guardian of the person. Guardian of the estate, that's the person who makes financial decisions for the ward or the incapacitated individual. And then there's a guardian of the person. That's the person who takes care of the ward on a daily basis. And there are times where, there are two different people that are serving in those roles. And there may be some disagreements as to, how that individual should be taken care of and, the money that should be spent on that individual's care between those two people that are serving in those capacities. Joint ownership. This is another way that people sometimes transfer assets to their loved ones. And there are two primary types. One is a joint tenancy with right of survivorship. Even though the word tenancy is included, it's actually an ownership. But basically what that means is, let's say a husband and wife own a home together, and there's a deed in place that says that, whoever passes away first, sole title will go to the surviving spouse. Well, that may sound simple and great, but there are issues with that. So we have this example here. Tom and Ann, they own the property together with this deed that says that Ann will inherit the house without having to go through probate. Great. Well, Ann gets the house, then Ann dies. Well, if Tom and Ann had children together, but Ann may have had children from a prior marriage, or she gets married after Dan dies or Tom dies, and then what happens? Are Tom's heirs, disinherited essentially? Well, here's an example of that. After Tom passes away, Ann remarries a guy named Dan. Then Ann dies. Dan inherits Ann's shares. Well, guess what? The children that Tom and Ann had together from Ann's first marriage, they get nothing. Everything goes to this Dan guy that Tom never knew. So important to have estate planning documents in place to avoid that type of scenario. Another thing that people do is they'll just start giving their stuff away as they get older. You may have a house in your name, and you decide to go ahead and give that house to one of your kids. So you deed it over to them as a gift. Well, first of all, you no longer have ownership of that house. And if your kid decides to sell it and you're still living in it, good luck finding a new place to live, especially in the Austin area, which is super expensive. There's also this step up in basis that's important to consider. For a lifetime gift, if you give your house to your child during your life, there's this, the basis is the cost of the house at the time it was purchased. So this example here on the left, lifetime gifts, your basis, the selling price. So your kid decides to sell the house for $350,000. The basis was $100,000. There's a gain of $250,000, and the capital gains tax could be $50,000, or somewhere along those lines. If you wait until after you pass away for the title to the home to go to your child, there's a step up in basis. So the basis for your child is going to be whatever the value of the house is at the time they inherit it. So, the kid decides to sell the house shortly after you pass away. The basis is, now $350,000 instead of $100,000. So there's not going to be any tax incurred. Beneficiary transfers is the fifth way of transferring things. And, if you do, and I'm sure you guys have had discussions with Scott and his team over at Century Management on making sure that whatever assets that you have that have beneficiary designations, like life insurance, like your investment accounts, your retirement, if you need to make sure that those forms are filled out properly. And well, what if there's a divorce? And if you don't change your beneficiary designation, what happens then? Or, you've named your kids there, but your kids are having financial issues, or maybe they have some chemical dependency issues, or they're just not good with money. What do you do in those scenarios? These are all things that you should be thinking about every few years, especially if there's a change in your marital status, or let's say one of your kids becomes disabled. All these things that may have an impact on those beneficiary designations. It may end up being a contested matter in probate. So definitely keep up with those things, because they are really important. Sometimes people will just say, well, I want my estate to be the beneficiary. And to me, I don't even think that's proper, just because, well, your estate didn't exist at the time that you wrote down my estate on the paper. But by default, it's going to go through the probate process anyway, because, the courts have to determine, well, who is your estate and who are your heirs of that estate. So putting my estate really doesn't serve any purpose, because it's going to go through probate anyway. And of course, if you have minor children, they're still under the age of 18 when you pass away, and you've listed them as a beneficiary. Well, that's probably going to have to go through the courts as well, because whoever is managing that money they're not going to stroke a check to a minor. They're going to want it to go through the courts. And oftentimes what happens is the court holds on to that money until the kid turns 18, and then they get this big check. And, I think we all made different decisions when we were 18 as opposed to, the age we are now. So, you want to make sure that you have provisions in place, documents in place that maybe, allow children access to the money that you give them over time, instead of in one lump sum when they become 18. So the last way and I think the most effective way to transfer your assets to your loved ones, is through a revocable living trust. With a revocable living trust, the whole idea behind this, going back to comparing it with a will, is, with a will, go through probate to change title to your assets. Well, with a trust, you set it up during your life. And if you're married, you and your wife set up a joint revocable living trust, and you transfer your assets into the name of the trust during your life, so that when the first spouse passes away and then, the second to die passes away, there's no need to go through the probate process because you've already changed title to those assets during your life. So that's why having a trust in place is a good idea. You keep control of it. You've created this trust, you've moved your assets into the trust. The terminology is you're the grantor, you're the one who created the trust. So as the grantor, sometimes other people refer to it as a trustor or settlor. These are all legal terms that are out there, but regardless, you maintain control over those assets, even though they're put into the name of the trust instead of your individual name. You have the right to change the terms of the trust at any point. So, you're not relinquishing control to anybody else. Now, again, if there's a family change, if you decide to, disinherit one of your kids, or your kids are at various stages in their lives where one may not need as much help as the other. So over time, you can evaluate your circumstances and those of your children and change the way the assets are going to be distributed over time. Again, it's all a matter of control and your ability to make changes. That's key. You want to be able to make those changes at any given time. And with a trust, it's easy to do that. You just do a trust amendment. And you don't have to redo the document from scratch. You'll just prepare an amendment, and you can do as many amendments as you want. There's no limitation to that. And that goes along with, the original document, and it's done. And the beauty of having a trust is that it's all private. You never have to go through any courts. A judge doesn't have to review the trust document to see if it's valid, and if that it was notarized and witnessed by two people. All these things that are required under probate law, you don't have to worry about when you're preparing a trust, because the whole point of creating this trust is to avoid the probate process. And here's a little diagram of how a trust works. All your assets are transferred into the name of the trust, and oftentimes that's referred to as funding the trust. So, for example, your house, a deed would be prepared that transfers title to the house from your individual names, if you're a married couple, into the name of the trust. And that deed is recorded with the county. You still maintain your homestead exemption, even though it's been moved into a trust. So you still get all the benefits of it. You just don't have to worry about it going through probate to transfer title, because it's already been done. Same thing with your checking accounts, your investments, your stocks and bonds, your family heirlooms or personal property, because typically, along with the documents, if you create a trust, there's one document specifically that says that you're assigning over your personal property into the name of the trust as well. So even if you have an asset that doesn't specifically have a document that establishes title, you can still move those things into a trust. This is just kind of a funny picture, but you control inheritance. Like I was saying earlier, let's say, you and your spouse pass away, or if you're not married, you pass away, you still have children that, you know, they may be adult, they may be over the age of 18, but they may not be at a point in life where they would make, sound financial decisions. So you wouldn't want them to get a lump sum and then just go, waste it on things that, young people would waste it on. So what you would want is to have in the trust document or even in a will, language that says, okay, I want, my child to have access to, let's say, a third of what I leave to them, by the age of 25, and then another third by age 30, and then the full access by age 35. Those are just examples, but it allows you to still have control over how assets are distributed even after you pass away. So it's a nice thing to have in place. Also, if your children are still minor, you can also have provisions of making sure that a trustee is named to, handle the finances for those minor children as well as to take care of them on a daily basis. Let's say there's a child with special needs. Well, you can have provisions that would, create a special needs trust or a supplemental needs trust. And, those assets that are placed into that trust would not be included in the calculation of, getting governmental aid. So that's good as well. Also, when you leave money to your children in a trust, you get asset protection. So if they get sued, or, they get married and God forbid, they get divorced, well, whatever you leave to them in a trust is their separate property. So it's not going to be subject to a divorce decree or a property division in a divorce. And it's not accessible by judgment creditors. Anybody that gets a judgment against them in a lawsuit wouldn't be able to go after anything that's held in that trust because technically it's the property of the trust. It's not their individual property. Even, they could ultimately become the trustee of their own trust. And as long as that money is held there, it's protected. Yeah, so I just say, it's protected from creditors and predators. So with a trust, you avoid probate at death, prevent court control of assets at incapacity. You get all the privacy that you want. It allows for quick distribution of assets to beneficiaries, so you don't have to wait months, sometimes years on the probate process to have access, for your beneficiaries to have access to what you leave to them. You have the ability to keep the assets in a trust even after you pass away and get that asset protection. Prevent unintentional disinheriting. What this means is, husband and wife are married and husband passes away first, surviving spouse gets remarried. That's she passes away first, and then the children from the first marriage are cut out. They don't get anything. A trust will allow you to set up a family trust and a marital trust whereby the children from the first marriage, your children, after you pass away, it ensures that your children will be taken care of regardless of what happens after you pass. And then the last thing is you can reduce or eliminate estate taxes if you're married. Right now the estate tax is high. It's 13 million plus adjusted for inflation per person, but that's subject to change next year. There was in the tax reform bill in 2017, the estate tax was doubled from 5 million to 10 million. It's been adjusted for inflation, so it's, upwards of 13 million now, but it's subject to go back to pre-2017 numbers. So it's going to go down to 5 million adjusted for inflation at the end of 2025. So that could affect a lot of you. Maybe you're not worth over 13 or 14, 15 million, but you're closer to the 5 million or so. And again, when I'm talking about your net worth, that includes the value of your life insurance as well. And a lot of times people don't really consider that to be part of their net estate because, hey, why is that included? I'll never see a dime of that money because it's only going to be paid out when I die. Well, federal government doesn't see it that way. That's the value of your estate when you pass away. And if you have a sizable life insurance policy, well, that might get you over that, estate tax threshold and subject your estate to having to pay some money to the federal government. So those are all things. Now, if you have a trust in place and you have some tax planning language in that trust, there are ways to essentially double whatever the exemption amount is. You can double it. There's no way to avoid it all entirely, but there are a lot of ways to minimize it. It all depends on the value of your estate, obviously. But you can purchase some life insurance and put it into what's called an ILIT, an irrevocable life insurance trust. And, if that life insurance policy is owned by that ILIT, it's not calculated into the net value of your estate. So, if that's something that is of concern to you, then you can certainly talk to Century Management about that, and I'm always happy to help out and answer those questions as well. Disability documents is what I referred to earlier. Anytime you're still living but unable to make decisions for yourself, you want to make sure that there are people designated to make those decisions for you. If it's a married couple, you name your spouse, and then maybe if you have some adult children, you can name your children as the alternates. But that may not always be the case, so you want to make sure that you identify people that not only are trustworthy, but, have the ability to make those types of decisions for you. You may, so that, for example, you may trust somebody to make financial decisions for you, but maybe not medical decisions. Maybe somebody that has a medical background that would be better to make those decisions. Or maybe somebody that has a financial background or is good with money that can make the financial decision. So those are all things that are important to consider when you're, thinking about putting these types of documents in place, because you're giving those folks a lot of power, and you want to make sure that they are comfortable in making those decisions. As far as medical decisions, there are 3 primary documents. There's a medical power of attorney, and then there's a HIPAA authorization or release. And those documents work hand in hand, because oftentimes you may have a medical power of attorney, but that doesn't in and of itself give the person that you've designated as your medical power of attorney to have access to medical records. And if they're making a decision, a medical decision on your behalf, it's important that they have the ability to access those records so they can make an educated decision. So, having a medical power of attorney as well as a HIPAA release is really important. The other document listed here is an advance directive. Oftentimes referred to as a medical directive, and sometimes informally referred to as a living will. But essentially what that does is it's a document that says if you're ever in a terminal or irreversible condition, and really the only thing that's keeping you alive is life support, feeding tube, breathing tube, that type of thing, you make the decision now while you have the ability to do so, on whether you are going to be kept on that life support or whether you're going to be taken off that life support. Don't leave it to, your family members to have to make that decision, because you may not have wanted what they ultimately decided to do. And oftentimes, if there's a disagreement among your family members, on what should be done, well, then that's going to create a lot of stress and trouble and potentially legal expenses. So if you have a document that expresses your wishes, that document will control. And, the medical provider will have to, or, they'll do whatever the document says. And if it goes to court, then the court will uphold your wishes in that document. So important to have that. A durable power of attorney is a document that is with regard to your financial decisions, accessing bank accounts, making real estate transactions. If you own a business, then it gives the individual the ability to make business decisions on your behalf. It's a whole litany of financial decisions that are included in a statutory durable power of attorney in Texas. And, you want to make sure that you've appointed somebody that you trust and that can handle those types of decisions as your durable power of attorney. Don't leave it up to the courts to decide that. The next slide is really just about, sometimes people are like, well, hey, you know what? I can do this myself. I can just get some online forms, and that's perfectly fine. Oftentimes people are able to do things on their own. Like the best example is, changing the oil on your car. Some people are, they know how to do that easily, no problem at all. By all means, do it. But, oftentimes the major difference between having an attorney prepare your documents versus finding online forms is the legal advice that you get along with it. You need to know what the provisions mean in whatever document that you get. If you decide to get something online, or if you go to the Lowe's or Home Depot or Office Depot, wherever they sell those types of forms, you need to know exactly what those documents mean, and you need to know how to properly execute them. And oftentimes it's not what's in the document that counts, but what's not in the documents. If you're not familiar with the language in these types of documents, it's not really going to occur to you on what's been left out, especially documents that you find online. You don't know who the original author of that document is and how many times it's been changed, and whether it applies, whether it meets the requirements of the state that you're in. There are all types of legal issues that could arise if you try to do things on your own. So what I would say is, if you find documents online, at least have an attorney review it and get their opinion on whether those documents are the right documents for you. All right, real quick, protecting real estate investments. Many of you have investment properties. Maybe it's a home that you own that you lived in a few decades ago, and then you kept it, moved to a bigger home, and then maybe you've accumulated 4 or 5 single family homes. You want to make sure that those assets are protected. And a lot of times what people do is they'll just keep those properties in their individual names. what I suggest is first you need to make sure that you have adequate insurance on those properties. And you should also, anytime you have property that has increased risk, and typically investment properties where you're renting it out to a tenant, that's increased risk. You want to do what you can to take those properties out of your name so that if a lawsuit ever happened, that it would be the LLC or the entity that's sued instead of you individually. You don't want to, you don't want to run the risk of being sued in your individual name, because if there's a judgment, then they could go after your personal assets, your personal bank accounts. But if you have, let's say, a series LLC set up, and a series LLC is a specific type of LLC where you get liability protection for each home that you own. You form one LLC, but you create a series for each property so that each property gets its own liability protection. So if one, if there's somebody gets injured on one of your properties and they sue you, well, they can only go after the assets of that particular series and not any of the other properties in any other series. So it's almost like having, 4 or 5 separate LLCs, but you're not having to worry about having to manage, to pay for and manage 4 or 5 separate LLCs. You have it all in one. There are other ways to do it: a family limited partnership or a family limited liability company. It's kind of a higher level estate planning product. That's also an option for people that have these real estate investments. But again, the main thing is if you have those types of properties, to get those out of your name. Then I just have some other things here that we can talk about, but we're getting pretty close to being, at an hour. So Scott, if you want, I'll turn it back over to you. And if anybody has any questions, I'll be glad to answer those.
Yeah, thank you, Mathew. That's great. I have a couple of questions. How much does it cost to go to probate? And about, kind of what's a range of time that you can expect to go through probate?
Yeah, great question. I would say between $5,000 to $10,000 is fairly common, and that's for just a run-of-the-mill uncontested probate. I will say that if that's when you have a will, and again, nobody's contesting it. If you don't have a will, there's an additional process that you're required to go through called a determination of heirship, where the court appoints another attorney to represent the unknown heirs. They conduct an investigation to determine who the heirs are, and that process is even more expensive. I'm going through one right now. It was a friend of mine from childhood. I've known him since I was 5 years old. He passed away at the end of 2023, and he didn't have a will. He was only 51, and that probate is still not done. It's been almost a year. So it could be 6 months or up to a year sometimes, and that puts a lot of strain on on your loved ones, of having to, if there was a car payment in your name or whatever expenses that were being incurred by the decedent, the loved ones of family members have to figure out how to pay for those things until the probate is done, and they have the ability, finally they have the ability to sell those types of assets.
Mathew, are handwritten wills acceptable in Texas?
Yeah, those are called holographic wills. People, if they, sometimes on your deathbed, you'll just write something in your own handwriting that says, who you want to get your stuff. Those are recognized as valid and enforceable, but there are certain requirements that have to be met if you're trying to probate a holographic will. You have to prove that it's actually the individual's handwriting on that document. And there can't be any other, if somebody if the individual scratches out something and writes something else in, well, then the court is going to want to make sure that it wasn't somebody else that scratched that stuff out. So
Sure.
it could be
Right.
problematic, but yeah, they
You
are.
mentioned, like IRAs, pensions, 401ks, life insurance, and those typically have someone typically names beneficiaries in there that would bypass probate. So on an individual account, joint account, can you structure those to where they're transfer on death and because beneficiary designations are not embedded in most cases in those accounts at the brokerage firm or the bank, you have to add kind of an addendum that's a transfer on death piece. Um, Is that a probate asset as long or not if there's a beneficiary designation on it?
Yeah, those are typically non-probate, so retirement accounts, life insurance, those types of things, where you've designated somebody to inherit those assets after you pass away. As long as you fill out those beneficiary designation forms properly.
Or even on a taxable account, as long as you associate a beneficiary designation to that, it should be non-probate, right?
Right. It should pass without having to go through probate if those beneficiary designation forms are filled out correctly. And if the individuals that are named as the beneficiaries have the capacity and are adults and that type of thing, there aren't any legal issues surrounding that.
Bradley,
But
someone wants to do some estate planning, especially with these rules that are possibly going to be changing. Can you take some of your property and create a trust or take some of your, I don't know, an investment account, maybe it's your a home or piece of property, give it to a charity. So you get it out of your state immediately, you get the tax deduction now, but that you can still get income from that investment for your lifetime. So you're not just, you're giving up control of the investment because it's going to some other entity, but could you require them to give you income on that until your death?
yeah, there are various types of trusts and estate planning vehicles that we haven't talked about here today. It's all based on your unique circumstances of what your wishes are. But yeah, there are something called a charitable remainder trust where you can, basically give control over to a charity, but then have, money paid to you during the course of your life. And then after you pass away, it all goes to the charity.
It seems like when someone agrees to be an executor of an estate, maybe they didn't even know they were going to be named one by a loved one, but let's say someone's an executor of a estate. It seems like that's a really big time commitment to help go through probate or unwind somebody's estate. Physical time, maybe even expensive, and I'm assuming there's some liabilities bestowed upon the executor of an estate. Can you just talk about that a little bit?
Yeah, absolutely. First of all, when you have a family member who just recently passed away or has become incapacitated, you're already grieving, right? You're already suffering the loss of an individual. And to have to then carry out the role and responsibility of, somebody in a fiduciary capacity, such as an executor, trustee, or financial power of attorney. Yeah, it's an additional stress for those individuals. So you want to make sure that it's somebody that's willing and able to accept that role. But whatever you can do to minimize that person's role, I would say is better. Most people, they don't want to go to court. Even if it's one hearing. I mean, most people will be okay with one hearing, but oftentimes it's a lot worse than that, especially if it's contested. So, you know, yeah, it's tough. It's tough on those individuals, but if they have somebody who is an experienced attorney that can help them along every step of the way and just let them know, okay, here's what to expect, and they know how to get through the process. It just makes it easier on those individuals when they have advisors that can help them along the way.
How often would you suggest uh, to your clients or anybody that has to state documents, how often should they be reviewed by an attorney, by us as the planner, but you as an attorney? How often should that be done?
I tell people every couple of years, 3 to 5 years will be a good range, but you know, even a year or two, if there's a significant change in your family dynamics, then you'd want to take a look at those documents again and make sure that, okay, well, do I need to make a change here? Certainly in the case of divorce, but also just, who you've named as your financial and medical agents. Um, you know, maybe you're on the outs with them and or maybe they're going through their own stuff and they would no longer would be the best fit for that role. So yeah, I mean, oftentimes we put our documents in a binder. And that binder typically goes on a shelf. And I just tell people, hey, just put something on your calendar. Every other year in December to remind yourself to just review your documents. And if anything needs to be changed, make sure that you get that document changed while you have the ability to do it. And usually there's not a whole lot of cost involved in that. If it's a will, it's called a codicil. If it's a trust, it's an amendment. So, better to make those changes while you can instead of having to worry about the consequences of not making those changes later.
So if, let's say you don't have a trust, you have property joint owned, can you explain the difference between owning it joint tenancy with right of survivorship versus tenants in common?
Sure. Yeah, that's a good question. Joint tenancy with right of survivorship, you own it with another individual, and then after the first person passes away, the survivor gets full ownership of that property. A tenancy in common, and that's typically a married couple. A tenancy in common is a situation where, you and I may own a property together. And it basically, if there's not a right of survivorship attached to that ownership, then if I were to pass away first, instead of my ownership interest going to you as a survivor, my ownership interest will go to my heirs. And then you're going to have to, you as the owner of the other interest, now there's, a little bit of uncertainty as to, well, who's going to step in my place, right? So it's not ideal. It's not an ideal ownership structure to have a tenancy in common, because you're just leaving a lot of unknowns out there. You don't know who you're going to be owning this property with if something were to happen to the other owner.
Matthew, let's say you have a partners, couple, however you want to say, that they're living together, they're not married.
Yeah.
If they're living together, at some point, is it considered a common law marriage? And then there's these estate issues. People have a right to claim some of those issues as if they were a married couple.
Yeah, good
No
question.
documents done, or how does that work?
Right. In Texas, there are specific laws or um, there's a set of criteria whenever if somebody is claiming to be common law married to somebody else, um, there has to be cohabitation, and they have to be um, basically telling other people, holding themselves out as being married, even if there was no formal marriage ceremony or a license, a marriage license was not issued. Those are the two primary factors. They live together and they're telling everybody that they're married.
For how
But
long?
there's no time, there's no minimum amount of time on that.
Okay.
Um, but what that does is it just creates gray area, right? Well, um, you know, maybe they're just, are they really living together? Do they have, what if they have two different places that they own and they're sharing, time at each place? And what if they may have told a couple of people, yeah, we feel like we're married. And it's kind of an equivocal statement. It's not 100% clear. They're not telling people, yeah, this is definitely my spouse. And sometimes people that have been in a long-term relationship, they'll just refer to the person as their spouse. And, did they really mean that in the legal sense? This is my wife over here or whatever. Maybe they're just saying that to make the person feel good. Who knows? And I say this not in jest, but these are the types of issues that come up when these cases go to court, and a judge or a jury is having to determine whether that relationship was actually common law or not. And that's a big deal. If it's determined that they were common law married, then now this person, if you're a child from a prior marriage, and you're thinking that you're going to inherit everything, um, and you think that the person that your dad was dating isn't going to get anything, and all of a sudden there's this contested probate, and there's a determination as to whether there's a claim that that was a common law marriage. Now you're having to spend all these additional resources to have to go through that process. And if it is determined that it was in fact common law, then you know um, your inheritance may be substantially reduced. So yeah.
Okay. Well, let's go with one more question. So, what would you say are the common mistakes that everybody on the phone can say, let's at least make sure we don't do this? What are the, two or three low-hanging fruit common mistakes, uh, covering just what you said today?
Yeah, sure. um I mean, first of all, make sure that you're not one of those people that don't have something in place. um you know have a basic will at least, or have some basic disability documents in place. you know um Now, ideally, best thing to do would be to avoid probate, avoid legal fees, or having to go through the court process, avoid uh, potential taxes. Those are the ideal things. But um, like those examples that I'd given you, even when people have a will, maybe those things weren't well thought out. One example is Marilyn Monroe. When she passed away, she named her her acting coach, I believe it was, to get 75% of her estate. And she had trusted him to uh, give her, you know, her assets away to charity. Well, he never did. He gets, you know, he passes away, and then his spouse gets everything. She gets remarried. This person who never knew Marilyn Monroe, this new spouse of her acting coach's wife, ends up getting everything, and that's a significant, estate. So she had a will, but there were a lot of legal issues that were not, considered, and it just left things open to other people that would have never, the decedent would have never in their wildest dreams think that this person over here would get everything. So yeah, it takes a lot of thought and making sure that you have trusts in place that would really, make sure that your loved ones get what you are wanting to give them, but also that they're protected, that those assets are protected once they get them.
All right, Matthew. Well, thank you very much for all your time today and all the education. It's been great. Enjoyed having you, and everybody stayed on the line, so that's wonderful. So we'll get this recorded up on the website probably later tomorrow, Friday at the latest. So yeah, thank you very much, and thank you everybody for joining us today. We really appreciate it.
Awesome. Thank you, Scott. I really appreciate you letting me just talk to everybody here today. And if anybody ever has any questions, my information was left up on the screen. So, and they can always contact you for that.
Absolutely.
So thank you. Appreciate it.
Take care. Bye-bye.